All right. Good morning, everybody. Welcome to another Compliance Capers. My name is Sonal Patel with SP Collaborative, and I'm with my very good friend, Betty Hovey with CHCS Consulting. Hey, Betty.
Yeah.
Happy Friday.
Yeah, I know. Always good, right?
Right. It's always TGIF. I hope people know when we're typing in our hi hellos into the chat box that we do mean it. It is, thank goodness, it's Friday and we are in the second week of May. So, hopefully things are a bit warmer. Well, for you, it's been warm, right?
Not to rub it in, but yeah.
Not to, but you love to rub it in. Just a little bit. Well, it is finally a bit warmer here. The trees have all blossomed and they are turning into green leaves finally. We've had our tulip show. So we're going to have some more spring blooms here in the Chicagoland area. So, I always love the burst of color, the burst of flowers that come up. Even though fall is actually my favorite season, it is not spring. But there that is. I do enjoy the season change, and especially the spring flowers are just a delight. So hopefully everybody in the audience is somewhere enjoying some springtime as well, and you're not suffering in the cold that I know up here, have been enduring for a few months. So.
And y'all can get it as pop-ups anytime up there. Be like
Yes.
May, and y'all could be having snow next week. So
Don't say it, you guys. She just said that out loud. Don't jinx us. Oh no, I hope not. I know I'm a Midwest girl, and you are right. I have been in the Midwest when a good friend of mine, he actually got married, had his reception in Cleveland the weekend that it happened to snow, and it was the last weekend in May. Last weekend in May. So yeah, that was years ago. So hopefully we don't have that repeat again, since you just put a hex on all of us here on the Midwest. So
I knocked on wood on my wooden desk over here for
thank you. Thank you. And I hope your crystal ball is like cracked and broken and it doesn't work. Right?
Yes.
All right. But again, it's Betty and Sonal together again, and we always digress and have a great time laughing. But let's try and keep on track. We are trying to talk about our month of corporate integrity agreements. So I hope you all in the audience had some time to catch up on last week's episode, because we know it was a big one. It was the first episode, obviously. So we really wanted to talk about the background details, the juicy bits, because there are so many involved in a corporate integrity agreement. So please take time to go back to last week's episode, because that is where we really did dive in and talk much more in depth about the background information on what goes on. So in this week's episode, we wanted to put the spotlight on another CIA. However, in this week's case, it is a smaller one. It is a integrity agreement, as it's called, a IA. So if you're wondering, like we were, when we were coming up with this concept for us for the month of May, what the difference is between a CIA and an IA, it's simply the fact on size. So the IA is simply addressed to smaller organizations or single providers, things like that. So in this week's case, we happen to be focused on a oncology practice in particular, and one particular physician involved. And there is another really good DOJ press release that came out. I put it up here on the screen for you. So for those of you who would like to please take the time, go ahead and read this relatively recent case and press release that came out on April 2nd, 2024. So brand new, guys. It was just about 1 month ago that this news came out for a oncology practice, physicians, and a reference laboratory to pay over $4 million to settle False Claims Act allegations. So, Betty, I'd love for you to pinpoint some of those juicy details there. And in general, where does it talk about the fact that there is one particular provider that they honed in on here?
Yeah, well, and this one, as you already said, Sonal, the practice is in San Antonio. So it got into an agreement with CorePath Labs. So what happened as you look at the details in here, they had a kickback, an unlawful kickback agreement. So the diagnostic laboratory was doing in-office bone marrow biopsy services for the San Antonio practice locations, and then did the subsequent diagnostic testing on the biopsies. And then what happened was CorePath, so who they brought in, paid $115 for each biopsy referred by the San Antonio Oncology and its physicians. And so they said that the payments for each referred biopsy were paid to the private practice entities of 3 of the physicians that were there. But the one that's named in here was the owner of the practices. So they bucked up against the anti-kickback statute, obviously with that. And it says that the CorePath lab failed to meet any statutory safe harbor. So they checked into that, and there was no safe harbor issues here. So it was just straight kickbacks, what they were getting. And they were submitting things to Medicare, Medicaid, TRICARE, all of these things had gotten claim submissions from this place. So what they were looking at, the doctor that owned the practice had to enter into, now this, since it's an IA, as we talked about last time too, smaller scale, targeted, and usually shorter. This is for 3 years, was her IA that they entered into. But once again, when you take a look at it, the claims that were resolved here were brought under a qui tam suit. So once again, there was a whistleblower involved. It was by a physician that was formerly employed. Just like in the last one, it was a physician that was formerly employed, as the head of that neurosurgery department. But this one was a physician that was employed by the doctor that owned the oncology practice. So a lot of the qui tam suits, when you look at them, are that way. It's people that were on the inside, that have all of that information to do it. So this was a qui tam one, and it was straight just kickback. We'll pay you $115 for every biopsy that you let us do, which of course leads to maybe doing more biopsies than you need to, and all of that kind of stuff. So that's kind of the down and dirty. It's a little bit of a shorter release. The release is like 5 pages, but most of it is talking about the things that the prosecutor was saying, about wasting the federal money and blah, blah, blah.
Right, of course.
But the nitty gritty of what was done, it was just a straight kickback.
That's right. And like we have talked about in previous episodes, people are used to kickbacks. People are used to referral fees, things like that in other industries, right? But this is healthcare, and you just can't do that here. So an accepted mode of business in other industries, you cannot do kickbacks here. And this was a good example of, like you stressed, unnecessary biopsies could be induced here, right? Because of that $115 payment that the practices would be receiving. So that's really, really well said and highlighted in this DOJ press release. And thank you also for specifying that this was in the great state of Texas.
Recently. At least it's not Florida or Illinois this time.
I know.
Not one of ours.
I know. And we're not shy. We do celebrate our states, and we know that we're in the news. Not we, but our states are in the news all the time.
Yeah.
Um, yeah. So,
Yes,
yeah.
I didn't.
No, no. Okay. So please take the time and find that press release and read it at your own leisure. But let me now pull up the actual report link itself for her integrity agreement for this Dr. Rao, who is named here in this CIA, Dr. Jayashri Rao, again in Texas. So in this particular document, it is a 26-page PDF, so much smaller than the one we were dealing with last week on compliance capers. And like our good friend here, Betty, has already stated, this particular integrity agreement, this IA, is going to be effective for 3 years. So like we stated in the first episode, these integrity agreements are not just for a month. Like the OIG is not just watching you for a very short period of time. This is for years. So they really, really did find a lot of serious deficiencies with what you were found with, right? So that's why when they come to these types of settlement terms, they are agreeing to not exclude you from the Medicare program or other programs, right? They are coming to terms and resolutions with you that you agree to in this integrity agreement. So you can continue working under the Medicare program and not be excluded. But again, they have all of these hoops that you have to jump through. So you have to read this document and all of its fine details to make sure that you go ahead and start retaining that independent review organization, that IRO umbrella entity that is now going to be in charge basically of what you are going to start doing as of the date you sign that particular IA agreement. You really do have to start embracing a culture of compliance once you sign off on that agreement and you're agreeing to all of these multiple terms that is outlined in the document. Yeah.
Yep. Yeah, I think looking at the agreement, you can kind of see too, if you compare this agreement to the one we looked at last week, you can see even from definitions and things like that, that you're talking about on a much smaller scale here of, who this is directed toward. So that's kind of where, I was thinking to kind of point a few things out to people to take a look at in the IA versus that CIA we were looking at last week.
Yeah, that's a great point. Because, when you take a look at their compliance program requirements that they document here, it's, in my opinion, when I perused it, it's very, very generalized for about 6 PDF pages compared to last week's report, which was much heftier compliance program requirements for about 17 PDF pages. They really went into specific details, but again, based on the particulars of what happened to that organization that we talked about last week. But still, a really, really clear and necessary roadmap for compliance, in my opinion, are outlined in these 6 PDF pages. Starting with the very first one, right, with that compliance contact. Like you have to have a pinpoint, right, like a main person who's going to be your compliance contact. Not a lot of practices actually have that.
Right.
Yeah.
Oh, I was just going to say, and that's a difference where they're not saying you have to have a compliance officer or a compliance program or a compliance committee. Well, you have to have a program, but a committee, they're saying just a contact, because when they're smaller,
Yeah.
They know smaller entities, even though these guys did something wrong, you still
Yeah.
don't want to make their integrity agreements so overburdensome they just can't
That's right.
fulfill it. So instead of saying you have to, get a separate compliance officer, have a separate committee with all these members on it, we just want a contact. You have to have a compliance contact. But it does state, they should not have, they shall not should not, they shall not, which means they can't involve
Mhm.
themselves in any capacity as legal counsel or supervising legal functions or having
Beautiful.
anything to do with billing, coding, or claim
Beautiful.
submission. So they're real specific, but
Beautiful.
they're not saying you have to go outside and hire. So it can be someone internal to the practice as long
Mhm.
as it meets this criteria that they're listing out in here. But then they tell you what the compliance contact, has
Mhm.
to do. But
Mhm.
you're right, when comparing it to the one from last week, you'll notice that they're much more concise, much more targeted to a thing rather than these large,
Yeah.
overbearing kind of requirements, because a smaller practice just, would not be able to meet those, nor would it be practicable for them to
Mhm.
have them.
That's right. That's a great point. And I love that you make it from episode to episode, is that when the OIG is developing these types of constructs, they are not trying to burden and overwhelm providers and practices and entities, right? They want to do things that is going to be pertinent and applicable to the size of the folks that they are dealing with. And like you so well stated, this is a small practice, right? And so the way this document is drafted is so it is not so burdensome, right? So that's a great takeaway. That's a great key point that we do notice when we review these types of documents as we dive deep from week to week. So that's a great tip that I wanted to pull out and make sure that the audience understands as well, is that the OIG is not trying to penalize everybody. They want the compliance to be systematically and methodically done in a way that matches the size of the practice. So
Yeah.
absolutely, yeah,
Yeah,
that's a
I mean,
great
they're
point.
giving them a shot, so they
Yep,
don't want to make it so that they just
right.
are going to fail because they just can't do it.
That's right.
So
That's right.
I think that is one thing that they do pay attention
Mhm,
to those kind of things, but they
absolutely.
are real specific on what they are to do, and that and this is where, when we get to my penalty section that I like so much, it'll show, these are the kind of things that, like, if you're not doing these things that we're pointing
Mhm.
out in here, that's when you get those daily penalties after a while. Because you'll notice too, if you look at the beginning of that with the compliance contact, it tells you that they have to have that within 90 days after the effective date. So after they sign this
That's right.
contract, they've got 90 days to get one. So it's not like they tell you tomorrow you already have to have it. So they do give them time to figure this out too. But then, 90 days is quite long enough to figure out who you want to do that. And
Exactly.
then if you
Yeah.
haven't done it, then we start getting those daily penalties on top of it.
Yeah, that's a great point. So the document starts out very, very clearly, right? That this type of deed has to start in 90 days. Like, you have a short window of time to go ahead and find the appropriate compliance contact. We can't just let this skirt on for the next how many years without a compliance contact. So it's not by tomorrow or by the end of the week. They give you time, and 90 days should be sufficient. So, yeah, that's another great, great point.
Yeah, same thing then with those review procedures where page 4, at the bottom, E starts,
Mhm.
that talks about the IRO.
Right.
And that is, again, within 90 days, they need
Yep.
to engage an IRO. So that gives them time to vet out places and to find one. In this
Right.
case, you would be looking for one that, had some oncology expertise and some lab expertise,
That's
towards
right.
like matching what your needs are, so that they are someone that would be qualified to be auditing those things for you, for whatever practice was under this IA. So, and it does say that, and then that they will be given access to all the records and all the personnel and everything they need in order to make sure that, their review is accurate and complete. And then it runs down into, like when they're going to do it, how many times they have to do it, what's going to be in there, and all that kind of stuff. So, they just get real specific with what's involved with the IROs too. And this one, I think, just had the IRO, right? There was not a Q. There's
Correct.
not a QRO with this because there's no quality of care issue. So they're
Correct.
just leaning down again, looking at comparing the two integrity agreements that we looked at. Last week's was like huge and covered a
Yes.
lot of different things, and this one is specifically to just the IRO, that they don't need to get a quality review organization also.
Exactly. Right. That's a good differentiation point. In this one, it is just the IRO. And like you stated there on page 5 and 6, they start to talk about it, but in Appendix A, they dive deeper into the IRO requirements, what their expectations are, when the IRO has to turn things back around and send things over to the OIG for their review and their input and stamp of approval. And then they also dive into Appendix B for the claims review details as well. So the appendices section on this particular IA is much smaller than the one from last week, obviously, because there isn't that additional piece of the quality of care organization. So I think that's really, really good when you guys in the audience are taking a look at these types of agreements and trying to decipher what is going on and where you can actually find really great information for your practices. So yeah, that's a great point. I really do think that they follow the general compliance program guidances that were recently issued as well by the OIG, especially in terms of the language they use in terms of shall not, should not, and that differentiation that you talked about earlier, right? They really want to emphasize, what organizations can do, and they provide it in a timeline, right? Especially in this document, they give you that window of 90 days of when you need to start really, putting things in motion to help support and show that you are in compliance with this document that you've agreed to, this IA. So yeah, it's excellent. Did you want to highlight those stipulated penalties section there? And
Of
is it
course.
notably different? Yeah, I know it's your favorite thing. Are they going to be notably different than last week's? I'm going to presume yes. Since this is a smaller entity, maybe the penalties will be smaller. I'm
Yes.
just guessing.
Excuse me. Yeah. If y'all that are looking at the IA, the stipulated penalties start on page 13 of the document.
13. Okay.
And whereas last week, the stipulated penalties were $2,500 per day for the different sections, and that's for each violation. For this IA, they're $1,000 a day for each violation.
Okay,
So
so
if you have
less,
multiple
still.
violations for multiple days, I mean, it's still adding up, but it's more, it's less than half what the
Right.
one for the corporate one was. Although if you look at the 15th one, which is the one for the false for lying, it's still $50,000 for every time you lie. So they that one they didn't make smaller. It's like no, we're still going to get you for that one. But
Wow.
the other penalties, yes, they're a little bit smaller. But they do, if you look right underneath that, they do give timely written requests for extensions. So
I like that.
if you're
Good.
finding that you're having trouble, maybe the type of IRO you need, maybe you're having trouble finding one. You're truly looking.
Yeah.
You've been
Right.
interviewing, you've been talking to people, and either
Mhm.
they, are already involved in too many and they can't, pick you up, or you're having trouble finding one for your specialty that really
Mhm.
can, do a good job for your specialty. So you need an extension.
Yeah.
Don't just let the 90 days run out because you're going to start getting these penalties. They're saying, the provider may, in advance of the due date, submit a timely written request for an extension of time to perform
Mhm.
any act or
Yeah.
file any notification or report required by this IA. So just let them know, say, hey, but you have to prove to them. You can't just say,
Yeah.
hey, I want longer, I need more time, and don't say anything. Say, we've looked, we actually interviewed one, but it didn't work out. So, we're using this agency to try to help us find a new one. We need a little bit more time. They'll be like, okay, fine. I see you're actively doing it. We'll give you a little bit more time to extend for that and tell you how much longer that you can have, but just like with anything else with the government, they give you a deadline, either meet the deadline or well ahead of the deadline, let them
Mhm.
know that you're having trouble,
Right.
so that you're not going to get these penalties that start stacking up here.
Exactly. Yeah, I loved that point that they made in paragraph B for that timely written request for extension as
Mhm.
well. I think that's another great piece that the OIG, the CMS continues to do in the various documentation requests and things like that that they are used to sending out to their providers, right? I know you and I have a lot of experience where we've had clients that say, oh my gosh, we just don't have time. We have no time to meet that deadline of, 60 days or 30 days for documentation requests, et cetera, right? So they are used to receiving requests like that for extensions. And in this case, again, they've also clearly identified that it needs to be written and it needs to be timely.
Yes.
So I think that's an important inclusion that they make in this particular IA. So I applaud that. I welcome that. I just hope providers are reading this
Yeah.
minutia in the documentation, right? So if they're ever in this type of a situation, hopefully not, if they're listening to compliance capers, they have a little bit of time to get their ducks in a row
Yeah.
and follow the facts here in this particular IA that you can if you do it timely and if it's in writing.
Yeah.
So
Yeah.
yeah,
Well, and that's the other
that's a
piece,
great
the
point.
timely piece, I think is important too, because how many times have we gotten calls, that, oh, I got the letter for the records request and blah, blah, blah. And they call us and it's like, oh, well, it's like due in 2 days. Yeah.
At
And
the
the
last
one you're
minute,
looking
I
for,
know.
so here it does
I
say the
know.
last sentence there that timely is defined as a request in writing
Mhm.
received at least 5 business days prior to the date by which any act
Exactly.
is due to be performed.
Mhm.
So, they're not going to take the night before, the day before, the
Mhm.
day of saying, oh, I just can't get this done for you. But no.
Right.
So make sure again that, as someone said, which is a great tip, look through these things and see, about the timelines, the deadlines, all those things to pay
Yeah.
attention to it, because you
That's
should
right.
know well in advance that you can't
Yep.
meet that. It shouldn't be like the night before you magically figured out that you didn't have one,
I know.
so,
That's right.
make sure you follow all of the timelines that they give you in here. If you need to do something that's an exception to what they're
Mhm.
telling you to do.
Exactly. Yeah, that was a throwback to bad memories that you and I have, right? Being called the night before something is due and like having a mini
Oh,
stroke and a heart attack. Like how can we help you
yep,
in less
yep,
than 24 hours?
yeah.
Like,
Yeah,
you
and it'd
know?
be a new client. It wouldn't be somebody that I had a
Yes,
relationship with either. It's just like
right,
somebody calling you out of
right.
the
This
blue,
is
and I'm like,
someone
"What?"
brand new out of the blue. Like, how can I possibly help you? Like, in less than 24 hours turnaround without dying.
It's only 150 charts. It's, oh,
No
okay.
big deal. No big deal. To people who are already blind as a bat, it's no problem. Oh my
I
goodness,
know.
I'm sorry. We digress per usual on compliance capers, but um, I think this was another good, really well-written document for this IA that this provider has to, this just came to her in April of 2024.
Yeah,
So within 90 days, like we've stressed, she has to find a compliance contact. She has to get the IRO. So hopefully she is researching
yeah,
people across the country to hopefully help her be her IRO for these types of oncology services and items that she is providing at her practice, and these types of lab specimens, et cetera, right? So I think it's a really, really good thing. It's a really good integrity agreement for practices like this. We know plenty that are like this, small, this particular specialty, et cetera. I really think it could be a great piece of compliance documentation for them to file away in their toolbox as well.
yep, yep. Agreed. Totally agreed. Yeah, all good points, and all good things. I mean, which is why we like doing this,
That's
so
right.
that we can point these kind of things out for other practices to be mindful of, to make sure they
Mhm.
don't fall into these, I don't want to call them traps, because obviously this one was done on purpose, but
Yeah,
to fall into these habits, bad
right.
habits,
Bad
that
habits.
can get you in trouble, or anything, that is not on the straight and narrow in your practice. You got to always be, the head on the swivel kind of thing, and having that 360-degree view of everything,
Yes,
or
that's
have the
right.
right people around you to make up that 360-degree view, because it's that one thing that you're not mindful of that's going to come and
Mhm.
bite you. So yeah, that's why, doing something like this, listening to these things, reading, other things that are out there on different things, and watching the OIG, what they put out, all that's so important for a practice to make sure that they stay on the straight and narrow. So we're just here to help.
Exactly right. No, those are really great points, right? Because I think in the landscape today, I think so many of our really, really good providers and practitioners perhaps aren't doing things with any sort of, bad intent, etc. But, you know, I know a lot of providers when they come to me, or potential clients come to me, and they say things like, well, Dr. Patel is doing this, and Dr. Patel has been doing this for the past 7 years, and he's fine, or they say, but I've heard that this is okay.
Yeah,
When I hear things like that, that always gives me pause, right? Because then I know, well, you just want to be like the Joneses, and you just want to jump on that ship without having done any proper due diligence and research of your own. You're just trusting that Dr. Patel did all the work for you, and that's why he's fine for the past 7 years, right?
yeah,
So when I have people come to me like that, that's when I like to always just say, well, did you do your research? Did you do your own due diligence on compliance, on this referral matter? Is this possibly a kickback? And then we have to always have the long conversation on, this is healthcare, right? You can't accept kickbacks and bribes and referral fees that you can in other pockets of the industry in
right,
America, right?
right.
So, but I mean, yeah, hopefully the folks that are listening in today can find a lot of similarities here in our conversation, in terms of they too have had these types of providers, potential clients come to them with these sorts of hypotheticals, but he did it, she did it, etc. Right? It should always be taken with grains of salt. You've got to do your own research, and definitely look to folks on compliance capers, other places that are trusted resources, that we have attorneys on speed dial that we can refer you to. If you don't want to talk to compliance capers directly, we have other people that we can send you to make sure that you're doing the right thing, be it for oncology, be it for the neurosurgery from last week, all the other specialties that will be unfolding here in the month of May. It's just a good thing to do your own research. I really do think. And hopefully the audience likes these two documents that we've provided to them from last week and this week in terms of the quality of care CIA, as well as this integrity agreement for this specific oncology practitioner. So, yeah, I know I learned a lot from today's conversation as well, because we do have a lot of oncologists that we know and have tried to help over these years. So, yeah.
Yeah. I mean, you got to be looking out, keep an eye out on what's going on, because stuff changes, or you might get somebody approaching you saying, hey, we got this great deal for you. If you do this, we'll do this, and then, the bells start going off.
I hope the bells go off. Yes.
Yeah. The
Hopefully
whole sounds too good to be true thing, so yeah, you can say, oh, no, Betty and Sona, we're talking about that. I don't think it's good.
And they would say, no, that's way too good. That's way too shiny. So you shouldn't join that club. Yeah, no, exactly.
Yep.
We are the naysayers.
Yeah. Again, here we go again.
Oh my goodness. No, but that's so true. That phrase really does work in healthcare. If it's too good to be true, you really should just shy away from it, because healthcare is way too scrutinous.
Yes.
Yeah.
Check it out. Check everything out. And like you were saying, when somebody says some other doctor is doing this or that, you don't know what their particular situation is. Like we were talking about the safe harbors. Maybe maybe they fall under a safe harbor for whatever they're doing, but they don't understand what that is. So they wouldn't know to tell you that, but
exactly.
You don't. So, or maybe they just haven't come up on the radar yet for somebody. So, it may look all rosy now, but somebody might be a whistleblower, or they might come up in a random audit, and then all of a sudden, they're not so happy anymore when they talk to you and they say, oh, now we got these records requests and now they want all this money back, so you never know. You have to make sure you're taking care of your own practice and understanding what y'all are doing in your practice, and that it is compliant and above board, no matter what any other practice is doing or says they're doing.
Right. Yeah, that's spot on. Spot on. Yes, absolutely, Betty. I hope the audience got a lot out of today's episode on the integrity agreement for this oncologist. I really hope we can continue to foster conversations here on Compliance Capers. We have another fantastic episode for next week on a different integrity agreement with a different type of specialty or entity. So I'll just leave it at that. But it's going to be something unique, and yet another example of a unique integrity agreement that was developed. So, and agreed to.
You've pulled all good ones, so I'll say. So I really, these are all good ones to talk, because they're all different and they all have different things about them. So I think this month, it'll be nice, because every one of them is different and has some kind of different, shade to it that I think is good to talk about. So good pulls on all of them.
Awesome, my friend. Thank you so much. All right. So we will both be back again next Friday for our compliance capers in the month of May. Next week is also going to roll up into Mother's Day weekend. So wishing you happy Mother's Day. Everybody in the audience, happy Mother's Day as well. And we will be back together for our next compliance capers on corporate integrity agreements. So I'll see you soon, my friend. Thank
Same
you.
here. Thanks, y'all. Bye.
Bye.